Good afternoon. I thought today I would talk to you about what I call politically incorrect crimes. What does that mean? Is there a specific definition for it? No, all I can tell you is I have my own definition. And basically, a politically incorrect crime is one in which the ultimate sanctions involved are far more serious than the actual category of crime itself. Okay, and let me give you the two most obvious examples. The first is family violence. Now, in the state of Texas, if family violence offense can be a misdemeanor, typically a Class A misdemeanor, meaning that the maximum penalty would be up to 1 year in jail and up to a $4,000 fine. Now, it can increase to a felony under certain circumstances, such as if you choke the person, what they call neck compression cases. But the point is, even though it's oftentimes a misdemeanor offense, which means traditionally it's not a serious crime, the fact is extremely serious. The blowback on it, if you will, is very, very serious in some instances. Anybody who's paid any attention to the impact on professional athletes who get even charged with family violence is extremely serious nowadays. Well, it's not just limited to the professional sports. I mean, the fact of the matter is that in Texas, it can be a very serious thing to have the offense, which is an assault typically, classified as a family violence offense, excuse me. I mean, many employers won't employ somebody. I mean, they don't want the community of customers to be up in arms over the fact that someone's hiring a family abuser or whatever. Okay, so the family violence tag is oftentimes far more serious than the actual classification of the offense. Of course, when we talk about family, I mean, it can be siblings, parents, children, spouses, significant others. I mean, it's quite a wide scope of offense. Now, that in Texas, that they actually make a classification. They get a finding from the court, that it's a family violence offense. Okay, and again, this can lead to more problems than you might imagine. If it involves a person with which they say there was a dating relationship, or if it's a spouse, a protective order can be issued by the court, and oftentimes will be. A protective order is a special kind of order. It can be sought by a prosecutor, or it can be sought by the alleged victim, but it is a family law order, and it can be in effect in Texas for up to 2 years, and it can provide for tremendous restrictions and commands from the court. This can include having to attend an anger violence program. It can involve restrictions, great restrictions on access to children. It can result in having to pay attorney's fees, and so it goes. So again, it can lead to a number of problems. It can lead to the right to bear arms, all kinds of things. But the major thing is that if you get that tag, it becomes very significant with respect to employability and licensure, because again, certain offenses are looked at very seriously when it comes to obtaining professional or occupational licenses. The next offense is DWI. This is becoming a real serious offense on a lot of levels. The world has changed so dramatically with respect to this offense since, I would say the 1970s. I mean, I can remember when you could legally drink and drive in Texas. And I've had some people tell me, that's crazy, that can't be true. It most certainly was. And I remember it was very common. I knew people, and at the end of the day, they'd make a drink and take it to their car and drink it on the way home. You see, in the 70s, the maximum limit or the presumptive limit of intoxication was 0.15. That's almost twice the legal limit today. Okay, but the point is that DWI is treated much more seriously than it used to be. Now, one of the challenges is this. In 1984, the Texas legislature changed the law to prohibit deferred adjudication in DWI cases. And I'll just explain briefly. They have this in many states and sometimes under different names, but in Texas, that there are times where there will be plea bargains where a person pleads guilty, but they're put on a period of probation. The judge doesn't take action on their plea, but instead they're put on a probationary system for a period of time. If they successfully complete the probation, and of course, just to be clear, probation is in essence an agreement between the court and a party accused of an offense that foregoes incarceration and instead normally foregoes incarceration and instead the person is required to be supervised. That's why probation has now been changed to community supervision, kind of like personnel has been changed to human resources, but everybody still calls it probation. So deferred adjudication, what makes it special is that the charge is dismissed after you complete the probation. In 1984, that was eliminated in Texas. In other words, you could be caught with cocaine and charged with a felony and get deferred adjudication and have the charge dismissed by completing felony probation. But you couldn't do it with a DWI. And I had a case one time where I represented a man who would go on binges. And anyway, he went on a binge one weekend, and he was using cocaine and drinking Jack Daniels out of a bottle in his car, and he gets stopped like I think in the morning hours. They followed him from a alleged crack house, and they stopped him, and he basically said, "You got me. I've been driving around all night, using cocaine and drinking Jack Daniels, And he just confessed before the police officers could get a word in edgewise. Well, when he hired me, it turned out that he was charged only with possession of cocaine. And, it sounds strange, but it was his lucky day because the cocaine charge, it was his first drug offense. So I could pretty well expect to get him deferred adjudication, which I could not have done if they'd have charged him with DWI. So in a way, it sounds strange. They charged him with the higher level offense, but at the same time, they did him a favor because they gave him the chance to get rid of it. Okay. So as a result, you can get probation for a DWI, but you can't get deferred adjudication. So you're going to have a conviction on your record. Now, I will tell you there are some district attorneys' offices and some judges that participate in a thing called the divert program. And this is a controversial program where if it's a person is a first offender DWI and they have a completely squeaky clean record, no arrests, no convictions, this sort of thing, and they can attempt to persuade the prosecutor in certain counties that please put me on your own version of supervision and counseling, and then if I complete it, dismiss the charge. Now, in that instance, there's no plea, you see, and because there's no plea, there is no deferred adjudication. Okay, it's simply an agreement between the prosecutor and the defendant. So that exists, but again, it's a hit and miss thing. It's very difficult to get into such a program, and number two, some judges won't participate in it. So you have that kind of issue. But the point is that what used to happen was a person would have a DWI. The first DWI was it was usually a probation, and no jail time. They would have to go through counseling and everything, and then the second one, of course, was more serious, and oftentimes there was jail, but not all the time. But the third one, the third DWI is a felony. That means it's a third-degree felony up to 2 to 10 years, and then the fourth DWI, again, it's another conviction. Now that you have a previous felony conviction, you got a second felony, and they can also seize your car with a fourth DWI in Texas. So, but the problem is having a DWI conviction is now much more serious, even your first one, than it was years ago. I can remember years ago when I was on the admissions committee for the committee on admissions for attorneys here in Houston, that we would evaluate problem applicants to this and make a recommendation as to whether or not they should be licensed to practice law. In other words, did they have some defect in their fitness or character? And I can remember that a person with a DWI that they may have gotten in college or whatever, that wasn't considered any big deal. Now it's very serious. It's very serious, and licensure very serious, and people want to get in the medical field and things like this. It's a real problem. And in other words, it's something you can't scrub off your record many times. And so it's there, and it really is serious. And so the downstream consequences of DWIs now are so much worse than they were even 10 years ago. Okay, so my point is that even though you may have a DWI conviction that's a Class B misdemeanor, it could have a tremendous impact on your job. I know people that have gotten fired because they had a conviction, a DWI conviction, and I'm talking about a first-time offense. So just keep in mind, the fact that something may be a misdemeanor doesn't mean there aren't downstream consequences. Okay, well, I guess I beat that to death, and I'll talk to you next time. Bye now.